Subcommittee assignments. Beginning with House Bill 255 by Representative Bridges. I'm assigning that to Subcommittee 1. That's the Knox Subcommittee. House Bill 287 by Representative Carter to Subcommittee 1. House Bill 301 by Representative Bobby Reese to Subcommittee 1. And the following 5 bills are going to be assigned to Subcommittee 2, the Mumford Subcommittee. House Bills 414, 415, 416, 417, and 419. All of those deal with the same subject matter. Any questions about subcommittee assignments? Hearing none, let's move on into our agenda today. We have 4 bills on the agenda. I'm going to take these not in any particular order. I'm going to call first House Bill 286, Chairman Ron Stevens. Chairman Stevens, glad to have you with us. And I understand you have a committee sub that will be operating off.
I do.
Is that right?
Yes, Mr. Chairman.
Let me, before you begin, I'm assuming we had no one wanting to sign up except 2 on House Bill 316. Okay, that's a good thing. I forgot to recognize the judges of the day. Way back in the corner back there from the, is that the Western Circuit? Western Circuit. I remembered that from having practiced there at one time. Superior Court Judge Lawton Stevens. Thank you for being here, Judge Stevens.
Thank you very much.
And from the Athens-Clarke County State Court, Judge Kent Lawrence. Judge Lawrence, glad to have you with us. Did I miss any judges? He comes back in, help me look out for him. Thank you, Chairman Stevens.
Thank you, Mr. Chairman. This is our House Bill 286 substitute that we're working off of. Is nothing more than our annual controlled drug, dangerous drug housekeeping bill, where drugs are moved from one class of addiction, so to speak, or actually moved to over-the-counter status, or even new drugs come from the FDA. We, in the state of Georgia, classify them as, and it's just our annual housekeeping bill. So I'll take any questions.
And there was a provision in the bill that came out of subcommittee that after discussion between yourself and Vice Chairman Mumford and I, we decided to excise out.
That provision in number 6, if you saw the old bill, section 6 is completely gone.
Thank you very much. Chairman Franklin.
Thank you. It looks like sections 7 and 8 are also gone. The last we had section 5 on page 2. There's no page 3.
If you'd like, which one would you like?
Can you spell them?
Absolutely. Sometimes. And, Mr. Chairman, I would like to recognize somebody from the Drugs and Narcotic Agency over here and to our left, Mr. Rick Allen, big burly fella.
Glad to have you with us, Mr. Allen. Any other questions? Did you have a question? Okay. Representative Abdul Salam.
Thank you, Mr. Chairman. Mr. Chairman, the provision in Section 1 that's labeled G, dimethylamphetamine, would that be in line with some of the other amphetamine-type products or amphetamine-based?
It is similarly, but if you'll, what this did is it's a duplication. All this Section 1 does is remove the duplication. Dimethylamphetamine is a Class 1 narcotic, and so that members of the board of the committee will know, a Class 1 narcotic is in the area of heroin, those things that are not have a medical use. So they move them to a Class 1. A Class 2 would be something of an amphetamine derivative like Ritalin, for example, that would have a medical use. So that's the only difference.
So it'll stay in Class 1?
Correct.
You're not removing it?
Right. We're removing the duplication.
Further questions from members of the committee?
Have a motion on appropriate time.
Further questions? Vice Chairman Mumford.
Move to pass by committee substitute LC 33 1928S with all of its attendant sections.
Have a motion.
Second.
We now have a motion and a second that we give House Bill 286 by committee sub a due pass recommendation. Any discussion on the motion? Hearing none. All in favor of the motion, please indicate by raising your right hand. Thank you. Any objection? And it passes unanimously. Thank you very much, Chairman Stevens.
Thank you, Mr. Chairman, and members of the committee.
Chairman Ron Forster, House Bill 50.
Thank you, Mr. Chairman.
We got Daniel. Where is he? Somebody. Let Daniel pass those out for you, Mr. Chairman.
I'm not sure if I have enough for everybody. Well, it wasn't. I thought there was like 11 people on the
Yep.
committee.
Do you have a motion, Representative Randall?
Yeah. You didn't bring enough copies.
He's been wanting a hearing so bad. Glad to have you. I haven't seen your name on my sheet. It's not here, though.
Must be another committee.
All right. Thank you for being with us, Representative Chairman Forster. Take us through this little bill.
Okay, we're looking at substitute number 2, and I believe it's LC 29271 ERS. The Interstate Compact for Juveniles was first adopted in 1955. This new compact updates the 1955 Interstate Compact on Juveniles. The legislation I propose will enable the state of Georgia and Department of Juvenile Justice to become the participating member of the National Commission established for the purpose of providing administrative authority and services for Interstate Compact for Juveniles. Without this legislation, DJJ would be required to operate Georgia Interstate Compact for Juveniles under the Federal National Commission controlled by other states and their federal government. What I handed out to you is a map of the United States. The dark states are the ones that have already implemented this compact. The first 35 states to implement the compact have a seat at the table, so to speak, to make up the rules and regulations for this commission. And I would like to have Georgia at a seat at the table rather than California or New York, which you see are still blank. The Georgia Interstate Compact currently that's operated by the DJJ has sole responsibility for providing oversight for all juveniles who leave or come into the state of Georgia under the ICJ provisions. It provides for the welfare and protection of juveniles, the public, and the state by providing the cooperative supervision of probationers and parolees and the prompt and safe return of juveniles who run away, escape, or abscond from legal supervision. The current law in 39.3-1 is used to regulate the movement of juveniles across state lines, was written in 1955, as I said earlier, and is intended to serve 4 major purposes: the cooperation and supervision of probation and parole across state lines, the extradition of juveniles who have been adjudicated by the court and escaped or absconded to other states while under the court's jurisdiction, the extradition of juveniles who have not yet been adjudicated delinquent but have been charged as being delinquent, the return of non-delinquent runaways to their home states when informal arrangements cannot be made between the holding facility and the runaway's parent or guardian. Now, the current law in the Interstate Compact for Juveniles operates under a structure established since the 1950s and is no longer effectively execute the above 4 major purposes. The inability to effectively carry out the above functions is due to the following reasons. Since the 1950s, many complex juvenile cases now combine concurrent jurisdictional issues with other agencies and systems. The current law and compact does not address shared compact processes or juvenile issues that may fall concurrently under the adult parole and probation interstate compact, which we implemented 4 years ago, I believe. The current compact has been amended numerous times, but is inconsistently applied and enforced among states that have ratified all the current, some of the amendments from the past. Some states have adopted all amendments, but many states have only selected amendments. Local jurisdictions often are unaware of the ICJ process or availability of services, or are unwilling to follow the rules and regulations regarding the transfer of cases, and simply order the offender and a family to move to another state as a condition of probation. Juvenile offenders and runaway youth who have fled their home states and are located in other states are sometimes quickly returned safely, but are sometimes detained for excessive periods of time in detention centers, along with serious juvenile offenders. Juvenile offenders are often sent unsupervised and unescorted to return home, or sometimes simply put back on the road with a warning to go home. The current law and ICJ Interstate Compact for Juveniles do not clearly enforce physical responsibility for the Interstate Compact for juveniles when they cross the jurisdictional boundaries, and that often leads to delays and denials of essential services. Local courts are often unwilling to consistently apply or enforce the ICJ rules and regulations, and in many states the current ICJ Compact functions are sporadically and inconsistently based on a local availability of funding sources. Georgia is a state with a deep and long-standing commitment to fulfill our responsibility regarding the Interstate Compact on juveniles. Statistically, we're one of the top 4 states in the country reporting the Interstate Compact caseloads. The proposed law and new compact will support the aforementioned 4 major purposes by establishing clear rulemaking authority and provisions for meaningful sanctions to administer and enforce the operation of the compact. The new compact will accurately reflect and respond to the legal system, social needs, and the juvenile justice system. By doing so, it will increase community safety, the protection of juveniles involved in the system through consistent and uniform enforced controls on the movement of all juvenile offenders. It will ensure that serious, chronic, and violent offenders are not allowed to slip through the cracks when they leave the jurisdictional area served by the original court. It will assist juvenile offenders to relocate in such a way that costs for services and care are not shifted from jurisdiction to jurisdiction, or that youth are not left as wards of the state after their parents have moved. The compact rules will prohibit local jurisdictions from shifting costs of care or treatment to other states without the approval of the receiving state. It will ensure juvenile offenders and runaways are promptly, safely, and securely returned to their home states through an appropriate and consistent legal process. The compact assures that rules and regulations are promulgated in such a way that they are significantly reduce the liabilities of states and their agents regarding the actions of juvenile offenders and runaways. Its rules and regulation process will reflect the needs of all states and the systems involved, regardless of the state's size or population. And that's if we pass this compact and are at the table to assist in making these rules. As you see, 31 states have already implemented this contract. And as I said before, I want Georgia to be at the table. Now, either we're at the table or we're outside looking in, waiting to see what happens. Or, if we don't pass this this compact, we will eventually have to have an individual compact with the rest of the other 49 states and be an island on our own. Now, as you can see, with Texas, Kentucky, our surrounding states already implementing this compact, this is not a compact we're going into with, communist China or North Vietnam. California's not on there. So I would ask for your considerable recommendation and pass of this compact. And I have asked the people from DJJ to answer any specific technical questions you guys have. And I believe there's an additional section to this bill that was added by the prosecuting attorneys for an update of the international dealings with juveniles. Thank you, Mr. Chairman.
How far does this take us in dealing with international issues?
That's a great question, Mr. Chairman. Let me see where.
Well, I'm asking you.
Well, that's what the international portion was developed by the prosecuting attorneys, and actually, your own
Jill Travis.
Jill Travis can answer that
Part of
question.
International law. Well, I'll come back to that one. Now, I understand we have a compact right now in Georgia law, right?
Yes, sir.
Okay. What's wrong with the current compact?
Well, there were 10 things that I read off. You want me to read them again?
No.
Okay. I'm sorry, I must have lulled you into a trance there while I was going over them. There were the purposes of the original compact were cooperative supervision, probation, and parole between the states.
So we don't have all of that now. Is that what you're telling me?
Right. With technology changes and amendments over the years since 1955, some states had implemented some amendments, some. It was just inconsistent dealing with juveniles, and that's what this new compact does. This is model legislation from CSG.
No, this is not ALEC.
No, sir.
Now, my understanding is DJJ. I want to be clear on this. Do they have a formal position on this bill?
As far as a department, I mean, they're in.
For or against it?
They're in support.
Okay. And I understand they have a compact administrator over there.
They absolutely do, sir.
Okay. Is that person here today? Do you know?
No, she's
No. No. Okay. Okay. That completes my questions for now. Representative Randall.
Thank you, Mr. Chairman. Mr. Chairman, do you think the former chair of Interstate Corporation would be in favor of this bill?
I absolutely do think that the former chairman of Interstate Cooperation would be in favor of this bill because of her concern for juveniles in our state and the nation.
One other question. I'm going to test my comprehensive skills here. So basically what this bill does is puts in place just some across-the-board rules and regulations between all of the states that have signed on, right? Doesn't try to enforce anything let's see, it says rules and regulations to govern supervision or return.
Right.
And that's it, right?
Well, actually, it develops a nationwide commission to set rules and regulations.
Okay.
And that's why, like I said, the first 35 states that passed the compact that talks about, and in the compact itself, it talks about dispute resolution, oversight, etc.
And
they will set the rules and regulations on
and
that
according to
commission.
this map you have, it's 31 signed on?
Approximately 31 states have already signed on.
Okay, thank you.
Chairman Franklin.
Thank you, Mr. Chairman. Chairman Forster, if Georgia enters into this compact and our views at the table do not prevail and the majority decides to do things that we might not particularly agree to because since we are then in the compact, are we bound by the rules that that compact sets?
On page 15, that's an excellent question, Mr. Chairman. On page 15, you'll see Article 11, Section A, withdrawal, default, termination, to be able to, the state withdraw from the compact.
So other than withdrawing from the compact, we would, if we stayed in the compact, we would then be bound by whatever the compact.
Ye-
whatever the connect-
Yes, sir, that's correct.
And if you let me with one more question. On page 2, line 29, that subsection 5, provide for the effective tracking and supervision of juveniles. Is there a reason why we want to track all juveniles and not just those that have been accused or found guilty of something? Or?
Well, that is for those that are under the adjudicated or whatever that word is. Is that the right word? Adjudicated.
Does that take care of you for now, Chairman Franklin?
So
Okay.
far.
Adjudicated. I'm getting adjudicated right
You
here.
and I failed to call on Representative Benfield, so I'm going to recognize her and then come back to Vice Chairman Mullin.
Thank you. I have a couple of questions. My main question is, who asked for this bill? Did the DJJ come to you, or the Council of Juvenile Court Judges bring this to you? What's the genesis of this bill?
As you know, a couple years ago, I became chairman of Interstate Cooperation, and I take this position pretty seriously. And so, with ALEC, CSG, NCSL, the other organizations, I always check up and see what the model legislation that they have, what's in place, what could affect Georgia from a nationwide perspective. And this was one of them. This is one of the model legislation bills that I saw that I felt Georgia needed to be a part of to help get us that seat at the table. And I have other bills that I'd worked with the Department of Juvenile Justice, and brought this up, and they were positive about me introducing it also.
Can I ask a
Sure.
follow-up to that? So the language for this, I'm assuming this is model legislation that's been introduced in 31 other states,
Yes, ma'am.
maybe some others where it's pending. Where did the language for is this NCSL? Who
CSG.
drafted the language for this? CS
Council of State Governments.
Okay, and I have a few more questions, Mr. Chairman. I'm looking in the finance section on page 13. That's Article 8. It says the Interstate Commission shall levy on and collect an annual assessment from each compacting state. Since some other states have passed this, we should have an idea of what the costs are. What type of funds are we talking about?
I see a budget impact. We had not a physical note, but a review from the Department of Juvenile Justice, and it showed that annual dues are estimated at $27,000.
And whose budget would that come out of? Would that be the judicial branch?
I would assume it would come out of the Department of Juvenile Justice, since they would be working through the commission.
And they're supportive of this. Okay. The following page, 14, the State Council for Interstate Juvenile Supervision. So we're going to create a new council within state government to monitor this. Is there already, I'm concerned about duplicating services. If we've got DJJ, do we need to create the state council? You know, some of the criticism we have here in state government on transportation is we have Greta and we have Department of Transportation. We have all these entities out there that are duplicating services. So my concern seeing the State Council for Interstate Juvenile Supervision is that there are already agencies in place that could handle some of these issues.
Right, and I would have to turn that question towards the commission.
Are you asking?
Yes, sir. If
to recognize
I could
someone
read.
from DJJ?
Yes, sir.
Sure.
Spiro Emmer, Legislative Liaison with DJJ. We've also got Amy Howell, our Legal Services Director here. Just to be clear on our position, we're really neutral on this bill. We have been working with the Governor's Office over the past couple of years to analyze the impact of this bill, and have been working with Chairman Forster, providing technical support, and would be happy to answer any technical questions to the best of our ability. But we are officially, we have no position on the bill. But I think to answer your question, yes, it would be creating a new commission that would be separate from DJJ.
Well, would there be a duplication of services? Is DJJ currently supervising interstate issues with runaways, truants, delinquents?
Yes, we do have a compact administrator that's housed within DJJ, but I think there's some question as to the nature of how the new compact administrator, how that system would be set up.
That take care of you for the moment, or you got a follow-up?
Do you have another question?
Before you
Go
might
ahead.
get a clarification on what did you say this would negatively affect what you're doing? Is that what I gathered?
No, I did not say it would negatively impact. I'm saying that there is no clear answer. Yes, it would be creating a new commission, but you know, it remains to be seen what the actual impact would be. The budget numbers are just an estimate.
I'm sorry.
And it would, to our estimation, it would come out of existing funds.
I'll say my questions. I have a few more, but
Okay.
I'll let others go.
All right, I'll come back to you. Vice Chairman Mumford.
I think I'm going to direct this to Ms. Howell. That's all right. The current interstate compact is enacted by a code on a piece of model legislation that's currently in our code. Is that correct?
Yes.
And it sets forth whatever rules we have for dealing with juveniles in other states or sending juveniles back to other states.
Yes, that's correct.
This procedure is going to abolish that code and replace it with a set of rules and regulations promulgated by a national council. What do you call it?
Commission, I believe, is the term.
A national commission. Do we know what those rules and regulations are going to look like?
No, not at this point. At the point that the 35th state ratifies the compact, then the commission will convene and determine the rules, and there's a set of procedures for.
Have y'all been? I know you must have been studying this. I mean, does your compact coordinator go to meetings and talk about what's going to be done? I mean, is there? I don't want to buy a pick and a poke. Are we? Do we have some clue about, you know, what those rules and regulations are going to look like?
I believe the rules will cover factors regarding the transfer and supervision, data collection. The dispute resolution mechanisms are basically in the bill. It's a binding arbitration. So those things will already be set, but the specific, I guess, procedures for how disputes will be brought forth and otherwise would be established by this commission.
Does that mean that if a Superior Court judge is sitting here in Georgia and says it's going to be this way, or a juvenile court judge, that they can be overridden by binding arbitration in Chicago, Illinois?
I believe the language of the bill.
Place?
I believe the language of the bill says that the compact supersedes all state laws and constitution.
I think some more laws like
If we won't need the states then. While you're up, Ms. Howell, walk us through briefly. I saw mention a couple of times at least, I think, in the bill that this gives some automatic jurisdiction to a federal judge in Washington, in the federal district court in Washington D.C. to interpret some of these disputes. Is that accurate?
Yes.
Okay. So would it be fair or unfair? I don't want to be simplistic, but would it be fair to say that we would be ceding to the federal court system some degree of supervision over our juvenile justice issues here in Georgia?
Yes, that would be a fair interpretation.
Okay. Secretary Bearden, and then Representative Abdul Salam.
This is my
It is now.
Just address, if this bill does not pass, do we hamstring DJJ, or we continue moving forward as we are?
I believe the language that's either in the compact or the materials that are distributed by the state governments is that after the 35th state ratifies, there's a 12-month period where existing compacts are active. So we would have 12 months, and then at that point, I guess we would have to evaluate whether we would enter into individual agreements with each of the states,
Or this one.
or we would have the opportunity to pass the legislation.
That answer your question? Okay. Representative Abdul Salam, and then Representative Levitas.
Thank you, Mr. Chairman. I have a couple of concerns, I guess. One, when we use the term juveniles and understanding that various states define juveniles at different ages, does that take into consideration, is that taken into consideration once you become a part of that commission, or are we expected to be uniform with the other states in terms of what they define as a juvenile?
That's what the commission's going to do. The commission will set those rules and regulations.
So the commission will tell
So it'll
Georgia
be-
what's the juvenile.
Well, it's going to have to be it's agreement between states, and it's going to be agreement for all the states for that definition.
Okay, and follow up, Mr. Chairman, if I may.
Sure.
Representative Benfield talked about some of the costs, and I think you said there was a $27,000 dues. Is that an annual dues? And what about costs of administration and costs for the council and costs for the commission and costs for the staff?
The budget impact shows an annual dues are estimated at $27,000, and operational costs for the state council will be estimated at $10,000.
You left that part out.
Sorry.
And no other costs?
That's what we have so far.
Thank you.
Representative Levitas, and then Representative Abrams.
Thank you, Mr. Chairman. Chairman, do you know where the juvenile judges stand on this? They have an official position in the state, Georgia juvenile judges. They have an official position on this one way or the other?
I haven't heard from the juvenile judges. If the DJJ have heard from juvenile judges on the compact. I haven't.
We've not.
How about may I jump in one second? How about the governor's office?
The governor's office hadn't contacted me on this bill.
We need, where's the floor leader when we need him down here? Send for him, okay. Representative Levitas, continue.
I guess what I'm wondering, and I think I misheard what Hal said, but I just want to make sure, if we sign on to this compact, let's say that there's a provision in a part of this compact that conflicts with our state constitution. I don't, and forgive me if I'm wrong, but if it does conflict, the provision conflicts with the state constitution, and some arbitrator in some other jurisdiction outside the state says you got to abide by this. I mean, I don't know if we can even do this by a House bill as opposed to a House resolution that would amend the Constitution. Have y'all looked into that particular issue?
Are you directing that to Ms. Howell?
To anybody that can.
Amy, you want to take a shot at that one?
We've not looked into the issue, but that is, I just double checked, that is the language in the compact.
Okay.
That'd be a Supreme Court issue.
Okay. Is that all?
Yes, thank you.
Okay. All right. Several hands are up. Representative Abrams, I was going to recognize next, and then Chairman Knox, did you have your hand up? A moment. Okay.
I defer to the lady.
Well, she was ahead of you anyway.
I'm trying to get some points.
And then Representative Everson, and then Representative Setzler. So that will take us through the next four. Representative Abrams.
To the representatives from DJJ, can you speak to whether or not, if we adopt this, what will the administrative needs be? I mean, will there be a merger of existing responsibilities into the new responsibilities? Would you need to actually create a separate bureaucracy? Can you talk a little bit about what the actual technical effect of adoption of this law would be?
I believe the language of the compact actually calls for an appointment made by the governor, and the person would serve at the leisure of the governor. So other than that, it doesn't speak to the actual construction of the position or the commission as it's described in the compact.
As a lawyer, I hate to ask you to do this, but can you speculate about what you think? I mean, because I think part of the concern is for those of us who are not often involved in juvenile justice, there's a concern about the layers of bureaucracy. But my question is whether or not there are provisions in this compact that are synonymous with what currently exists, and will you have to create new things, or will there be simply a merger of existing responsibilities and new responsibilities?
In terms of the actual administration of the compact, I think there would be a merger, so there wouldn't necessarily be a need for duplication of a person in DJJ who actually administers the transfer of youth. In terms of speculating as to what it might look like in terms of the agency, it might be something similar to the Children and Youth Coordinating Council, which is as a...
Just look at me.
The budget item is included in the DJJ budget, but has a separate direction for staff.
Thank you.
Chairman Knox.
Thank you, Mr. Chairman. Let me ask you, Mr. Chairman, I know a lot of this is going on with these compacts
amongst the states, and I'm not sure exactly what the impetus for it is. I see it has some benefits. One of the things, however, that does concern me about all these compact arrangements that we're making is that, to some extent, it seems like we're delegating our authority and our responsibility as legislators when we give it to some body, extrinsic body, to enforce these rules, to develop these rules, and so on and so forth. How do we get out of this if it turns bad, or is that any possibility?
Yes, sir. It was a question that was earlier. It's on page 15.
It wasn't here.
Yes, sir. Yeah, that's my page 15, Article 11, Section A, for withdrawal.
Are you concerned at all about another level of bureaucracy with the compact folks and then us, the feds, and whoever else wants to get involved?
Yes, sir. I'm concerned that we won't have a voice at the table for the rules and regulations for this compact, and so that I want Georgia to have a part on it so we can have a voice to make sure these rules and regulations are close to what we already have, or what we would think would be best for the juveniles in our state, and how we transfer them from other states to get them here.
Thank you, Mr. Chairman.
Representative Everson.
Thank you, Mr. Chairman. Representative Benefield asked a couple of questions that I had concerns with, but on Article 9 there, where it talks about the state council, could you elaborate a little more on how will the state determine who's going to serve on that council? How long the term for that council? I see it states that one representative shall be appointed from the legislative branch, I'm assuming the Speaker of the House, judicial, the Supreme Court justice, and the executive, the governor. How long are these terms on this council, on this commission?
The commission itself says the state shall determine the membership of its own state council, and as far as membership terms, I don't know that that's listed in there. We would have to determine that.
So as it currently stands now, if I may follow up, Mr. Chairman, it's indefinite. I'm appointed to that council. I serve there until I die.
Well, it would be like any other commission that we establish here. We would establish the term for those members.
Representative Ed Setzler.
Thank you, Mr. Chairman. I guess it's with trepidation I say this. I'm a pretty strong believer in federalism and states' rights, so I come from that perspective, overwhelmingly from that perspective. But it would seem that although the federal government is seen fit to involve itself in many things of the last 5-10 years that I question whether they should have been involved in, this seems like the precise kind of thing that our federal government ought to be doing, is making decisions about interstate issues like this. And maybe I missed something earlier in the discussion about why compacts versus federal action, but it would seem rather than having this voluntary compact of states, through this kind of discussion, we would just rest on the compact of states we have called the federal government. All 50 states are represented. It's called the United States House of Representatives and the United States Senate to address these issues, to kind of rule with federal authority on this. I don't really understand why we're doing this as a state. Why is this our business? Why is this not expressly the federal government's business to work these exact kinds of things out?
I actually think it's a little better by having all our states join together with members from each state to develop the compact than just having the federal unit do it themselves.
Well, I mean, the idea of joining together with other states, you've got Senator Isaacson, Senator Chambliss, Senator McCain from Arizona. You have 50 states are represented with their senators in the U.S. House. I don't know why that's not the appropriate place to do this. I don't know why we as a state are trying to create these new structures that it just doesn't seem natural to me that this is how this would flow. If you can share another example where these compacts have made sense and make more sense than the federal government, then maybe I'd be persuaded. But for now, this seems to be really not our job as a state legislature to create these new structures and compacts that we're tied together with other states that, you know, through this sort of ad hoc organization. I mean, I've not heard anything that's persuaded me that we need to do this in a way that couldn't be done in the federal government.
Other than it was first implemented in 1955, and we need to update it from then. And we have the 31 states that have already done this. And if we don't get it done, we're either going to be getting into it later after they've developed some rules and regulations, and we had no say-so.
I hear you. I'd be happy to.
I mean, I'm with you. I'm a states' right type of guy myself, but I can see the need for us to get this done.
I mean, if DJJ believes the existing system's not serving us as a state, and I would cede to their expertise on this. I don't know if they're saying that or not, but I'd be glad to take this to my United States congressman and say, hey, can Congress work on this? I just don't know that we as a state ought to be creating new ad hoc organizations that tie us together in, you know, loose ways.
Well, maybe it's because the federal government's much slower than the states are, and we're getting it done quicker.
Well, based on the implementation time on this, doesn't seem to be a lightning fast.
I know.
Well, let's tell them to refund S-chip before they take it.
Yeah.
Representative Collins.
This is a question for DJJ. And I know this just came up and Representative Seth, but is the current system broke? And if so, how?
I believe we do have some challenges in terms of the lack of uniformity and agreements. I can't speak to whether or not it's broken or not. We have challenges.
Okay, as my good friend Representative Abrams said, I hate to speculate here, but let's just say it is broke, does this fix it?
It's hard to say without seeing the rules.
My next question is Representative Forster, if the chairman is.
Go ahead.
She's
She's excellent.
The way I sort of, I think I heard your statement earlier is after the 35th state signs on to this, everybody else either has 12 months to opt in, opt out, or basically sort of play by their own rules, if you would. Or are we just sort of forced? Is this one of these things where we're just sort of forced in? When that 35th comes in, we're forced in it no matter what we do.
No. We're not forced in it. It's just now we're an island isolated by ourselves. As far as being able to transfer juveniles to one another, this would have been the question you should ask her.
Okay. I'll turn the question to her.
Because after that 12, ask her what's going to happen after that 12 months.
Okay. You probably didn't hear my question.
I'm sorry, I didn't.
Okay. I'm coming back to you. What is concerning here, and it sort of seems to be taking us out of the process, that after the 35th state joins, the compact becomes official under this language that seems to be there. After the 12 months, or during that 12 months, we can either join it or not join it. What happens after the 12 months? What if Georgia just says, no, we're not, but then at the same point, what's the effect? Are we an island to ourselves? Do we have to go around and get 50 different compacts with 50 different states? Or can we still operate in life going nice?
49.
Well, depending on what happens with the bill, in anticipation of either seeing what the results of the rules are, we may then come back and again attempt legislation, or we would begin to work on agreements with each of the states.
49 states.
Okay, thank you.
Vice Chairman Mumford.
Don't sit down. I know you probably don't know the answer to this, but do you have any concept as to how many children actually go through interstate compact statewide now?
I do. We have estimates. One of the things that I do think this is seeking to do is to have accurate data collection. But in fiscal year 2005, we transferred about 600 youth, and there were over 100 that were under supervision.
All right. And do you know, were most of those transfers to neighboring states, by and large, or were they all over the place?
What I understand is we transferred quite a few youth to California, but
Okay.
it's spread out.
All right. Did we transfer any overseas?
I can't answer that. I'm not aware of whether or not there were.
You just don't know the answer.
I don't know the answer.
Okay.
to whichever of you know the answer, and this is not an unfriendly or a friendly question, I'm just trying to find out, how long has the, I guess we call this a ratification process, how long has it been going on this particular compact?
2002, I think.
Okay. So the
I think.
31,
Do you have that?
the 31 other states that have adopted this have done it over a 5-year period of time.
Yes, sir.
And I'm a little interested, I mean, with all due respect, and this is not a flip comment, but California seems to pass anything. So why have they not passed this? Do you know?
I don't know, but I'm glad. So that we could have a voice at the table before they do. I think one of the reading on this, I think one of the goals was by 2004, because they were thinking in a couple of years, everybody would submit it and pass it, and within a couple of years that they would get it done, 2004, 2005, and then start. But here we are in 2007.
Okay. Representative Abdul Salam. And then
I guess this question would probably be addressed to both Chairman Forster and to DJJ. Looking at page 19, when it talks about the appointments being made to the commission by the governor, the lieutenant governor, and Speaker of the House, and Chief Justice of the Supreme Court, I'm struck by the fact that the DJJ does not get to make an appointment. I'm further struck by the fact that on that same page in section 2-2 that the duties of Department of Juvenile Justice are so minor. I don't know really what that means.
who would you want to take a stab
Both.
at that?
Are they cutting DJJ out, or are they taking the load from you, or is this oversight? Do you not need an appointment to the commission?
The governor appoints.
But we are part of the executive
You're
branch.
part of it.
So,
No, I didn't say that.
I mean,
Not
it's
what
the
it
nature
says.
of our agency. So if the governor gets an appointment, I suppose it could be the commissioner, but it could not be the commissioner.
Right.
And you raise it out.
Would you like me to?
I think that's as good as you're going to get.
Oh, and as far as the duties, I think to some degree this captures what we currently do. It's certainly not exhaustive of what we do, and we would interpret the statute to provide a baseline and then give us the opportunity to give additional services where appropriate. So.
If I might add, that's not the only duty. That was only pulled out because of the change. If you see on page 20, the change of removing it from Chapter 3 of Title 9 to Article 7 of Chapter 11, Title 15. That's the only reason that one duty's there.
That take care of you for now? Okay. Representative Levitas.
Thanks, Mr. Chairman. At the risk of winding up on one of Chairman Mumford's infamous subcommittees, I'm going to ask you this question. You mentioned a little bit ago that there were some problems that this compact addresses, and I guess my question is, could you come up with a list of what those problems are, present those to the committee, and could that be solved with legislation that falls short of adopting an interstate compact, which obviously has caused some folks on the committee some pause? That's for either one or both.
Get it to the gentleman to make some copies to pass out to you.
Right. No, I understand the problems you've raised, and it sounds to me like DJJ has identified maybe some others. I guess my question is there if we didn't, for whatever reason at this point, adopt the interstate compact, are the problems that you recognize that would be resolved, at least in part, by this compact, are there other means by which we could resolve those issues to you? And the answer may be no. Again, this is not a friendly answer to this question. And I do have one other follow-up question, which is, in the list of juveniles, when it talks about the list of juveniles includes, and it lists offenders, non-offenders, one of the things that it does list is non-offenders, so folks who have not been adjudicated delinquent. Who determines, but it says, I think, who are in need of supervision. Does the compact or some existing law determine which juveniles are in need of supervision and who would determine? I'm sorry, that's a big compound question.
That's okay. I'll answer the first question. In terms of potential ways to address the areas that we've identified, yes, there may be ways. I'd like some time to go back and talk with others. They may be administrative. They might benefit from your assistance. In regards to the language about youth who are non-offenders, I'm not looking at specifically what part of the compact you're discussing, but my thought is that it's talking about youth who have yet to be adjudicated but may be charged as runaways, returning them to the original jurisdiction for.
And that may be. I just and again, folks in the committee will tell you I'm not trying to fall in the box, but under on page
4.
Under starting at line 12, subparagraph 8, going down to subparagraph E, it says not, and it's given the definition of what juvenile means, and it says including, and then it goes non-offender dash a person in need of supervision who has not been accused or adjudicated a delinquent or status offender. And I'm trying to, is it a court of jurisdiction that already has jurisdiction over the juvenile? I'm just trying to find out what that means.
I think that would be somebody that goes into custody of defects to be transferred to our state to another relevant.
I would worry about a law that would give broad sweeping powers, even unwittingly, to anybody to monitor juveniles who don't fit the delinquent or potential delinquent status.
At the risk of speculating, since I didn't draft this language, my thought is that there are many states that have a designation that for persons or children in need of supervision who are neither deprived nor delinquent, they're basically in need of some sort of services or treatment or supervision. And so my thought is that that may speak to other states that have that status. So they would be under some level of court supervision and may abscond or otherwise leave their jurisdiction, and so would still be subject to a level of supervision, but are neither offenders or deprived.
Mr. Chairman, can I ask that?
Sure.
And do we have something like that in the state of Georgia?
We do not have that legal designation.
So if we adopt this, we would be adopting, as I understand it, without any kind of parameters for determining who fits that bill in our state, correct? That would have to come with potentially whatever the compact commission comes up with, right?
Well, I believe there's, for example, you have parents that move out of state and they they pass away, and then there's a child left there with no supervision that needs to be transferred back to the grandparents in this state.
Okay. Thank you, Chairman. Thank you.
Representative Benfield.
Thank you. Is this working? Okay. I want to thank the chairman for bringing this bill. I've had some experience with interstate compact bills. I was one of the sponsors of the UCCJEA, Uniform Child Custody Jurisdiction Enforcement Act. And I want to say it was I know it was at least 3 years. It may have taken me 4 years to get that through. And one of the reasons it took a while is it was like this bill. It was really thick. And one of the problems I encountered is, and I find with these model bills, that there's not a one-size-fits-all. And often you just take this model bill and try to fit it into Georgia statute, and it doesn't always work. And so it took me a while to work the UCCJEA through the process, and I think it's a good law because of that. So that's a concern I have, and so but I hear from you that there's somewhat of an urgency because 31 states have passed this. Upon the 35th, this kicks in, and then we will no longer, as you keep saying, have a seat at the table. And my question to you is, where does it say that? Because what I see is on page 4 at the top, compacting state means any state which has enacted the enabling legislation for this compact. And then on page 5 it says each compacting state represented at any meeting is entitled to one vote. That's lines 26 and 27. So where does it say that if you're past the 35th state to ratify this, that you don't have a vote and you don't have a seat at the table? And I'm not saying I'm opposed to this. I just want to make sure I fully understand what we're doing. We're not duplicating services. We're not creating too much bureaucracy. We're not.
Page 34, Part 6, Section 6-1. Which talks about upon enactment, no fewer than 34 states.
To the 34th page.
And then I mean, that's for our enactment of the compact.
That's the effective date.
Right, for the effective date of its. And the other section is on page 14, Article 10, Compacting States, Effective Date and Amendment. If you look at line 19B, this compact shall be effective binding upon the legislation and enactment of this compact into law by no less than 35 states.
If I can ask a follow-up, but where does it say that if you're the 37th state that you don't get a vote and you don't get to be part of the compact? Oh, wait, state Representative Abrams is showing me.
Any states defined in Article 2 is eligible to be a compacting state. Let's see.
Okay. Well, that's what he said. I just didn't find it here. Representative Abrams has pointed out to me it's lines 23 through 25 on page 14.
If is Representative Benfield's okay.
What I want to
Representative Abrams.
Thank you. I may have explained properly or improperly. What I believe you're saying is that upon 35 states enacting this legislation, there then is the compact takes effect. Those states then are the voting states to promulgate the rules and regulations. Any state that has not enacted the legislation is a non-voting member, and therefore, when you say they're not at the table, they are not. They can participate, but they cannot actually vote on the promulgations of the rules and regulations that will govern the areas of this compact that have not been established.
Right. And as far as I submitted this bill last year. Also. Yeah, but we didn't move on it.
Let me, we have some more questions, and I'll recognize y'all. I just want to sort of make a little scheduling update here for you. Chairman Knox was having a meeting of his subcommittee, subcommittee number 1, that, if I could have your attention. There may be some in the room that might want to hear this. Chairman Knox was having a meeting of his subcommittee earlier this afternoon, and by prior agreement, because this full committee had scheduled to meet, he suspended proceedings in that until we were finished with the full committee. This is a very important piece of legislation that Chairman Forster has brought to us that I think deserves the full airing out here by this committee. So I don't want to short-circuit this discussion. And I think we do have some more questions. And then we still have 2 bills after Chairman Forster's bill on the agenda. And I know that Chairman Knox and I and others are involved in a meeting that we will need to leave the building probably no later than 5:35 or 5:40 for. So in light of that and in light of the hour now, you're probably only going to have 30 minutes at most, and maybe not that long, to continue. And you think you told me you had, what, 17 or 18 witnesses signed up?
And still signing.
Is it your pleasure that then that we announce now that that meeting will not be held this afternoon, but will be reconvened upon your call in the immediate future? Okay.
I'd like to make that announcement on public.
Sure.
Quite a few people out there. If you want me to, I'll do it.
Okay, why don't you go do that then? That does not affect House Bill 270 or House Bill 316. No, we are taking those. Push back. Excuse me? I'm sorry.
I have a question that I'd like to direct to DJJ. You don't have to stand. Who is the person? There is a coordinator of the Interstate Compact designated. Is that correct?
Yes.
Is it safe to say that that person is probably the most knowledgeable person in the state regarding interstate compact matters?
Yes.
Is it safe to say that person is not here?
Yes.
Is it safe to say that person could be gotten here? Not today. I know they're a state employee. I'm sure they're working until 5:30.
Yes, they could come in just fine.
Who is that person?
Cindy Pittman,
Okay, and how long has she been doing that?
over 25 years, I believe. I may be.
Wow. And I'm sure she knows about this proposal. I mean, I'm sure she's studied it at length, right? You've talked to her about it.
She is aware of the legislation, yes.
Okay. I just wanted to know that. Sure.
Chairman Franklin.
Chairman Forster, again, I appreciate your patiently answering the questions.
Yes, sir.
I remember in my time here, we have done various multi-state compacts. Dairy, I think my first year we did one dealing with water in Alabama and Florida. And with these, we were always told all the states have to adopt the exact same language. There are no amendments, because if we amended the legislation, then it would not be identical to what the other states enacted, creating that particular compact. So my question would be, obviously this is a substitute of what was originally introduced, so if we pass something that has any change to it to what the other states passed, how would this have any force or effect if it's not identical like the other compacts had to be identical that we've introduced?
That's a good point. This substitute, the model language for the compact itself is exactly the same. Like I said earlier, what was additional was information from prosecuting attorneys for the international portion that we have in our code section currently, which you'll see in Part 2, Part 3, where the lines are. And you'll see the first part of this is the compact. There are no lines. That is the original compact language. So you're right. And that is the problem with the compact we have now, is many states have amended, have not, or for the compact amendments over the years, some of them have not incorporated or approved the amendments that were agreed upon the compacting states. And so that's one of the problems we're trying to resolve here also.
So you're saying the first basically 18 and a half pages
is the model language,
and the rest of it is in addition to the compact and does not specifically relate to the compact.
Right, that's an international portion update from the prosecuting attorneys from our current law.
But that would not be part of the compact.
No, it's not part of the compact.
It's basically riding on this
right.
bill, just like any other legislation that we do. We attach.
Yes, sir.
Thank you.
Any further questions from members of the committee? Further questions? You've had all your questions answered. Representative Abrams.
This is not that my questions have been answered. I guess this is a procedural question. Is it possible to, given the suggestions of Chairman Mumford and Mr. Levitas, is it possible to have a larger conversation with additional persons who can answer some of the unanswered questions? I think we've exhausted DJJ.
You're talking about the compact administrator for DJJ? I think that's certainly possible. Ms. Howell and Mr. Ambern, would tomorrow afternoon be possible?
Should be.
Okay. I know Chairman Forster is very anxious to have this matter resolved. Is that accurate?
This day 20, what is it? 23?
There's a big
22?
difference. There's a big difference in 23 and 29, Chairman.
Yes, sir, I understand. But not the pleasure of the committee. I mean, tabling the bill until tomorrow where the compact minister would be here. I thought she'd be here today, so that's fine.
Does anyone have anyone care to make a motion? Recognize Representative Bearden.
Make a motion to table House Bill 50 until Cindy Pittman can be here to take this forward.
Okay, we have a motion, and let me ask the DJJ representatives this. We are meeting tomorrow at 2 p.m. Is it possible? Well, let's put it this way. Would y'all just make arrangements to have her here? Okay. Yeah, and Vice Chairman Mumford had an excellent suggestion that anyone else from the department that could help us on this, because it's the chair's intent after we hear from these individuals. I want to accommodate the author, for whom I have much respect, and this is an important measure. So it's my intent that we allow this committee to pass upon this measure.
Thank you, Mr. Chairman.
Okay, we have a motion that we postpone further consideration of House Bill 50. And
are you meeting at 2 or 3?
the meeting tomorrow will be at 2 because we have a very, very short rules calendar, number one. And number two, in anticipation that since we are in adjournment or in recess on Friday, that perhaps some members would want to leave earlier than 6, 7, 8 o'clock to drive home tomorrow night. Does that excuse me? Let me ask this. I guess we're in the discussion stage of the motion. Does that conflict with a committee meeting tomorrow?
Yes, Health and Human Services.
At what time?
2 o'clock is our regular time of meeting, and we have several bills.
Okay. What time will you be finished?
I think it'll take probably the whole hour. But we should.
Days.
That's the CON committee. This is not the health committee.
Okay, 3:30 tomorrow?
Oh, 3. I mean, we should,
3? Okay.
Should be 3 at 3.
Does 3 o'clock tomorrow conflict with anybody? Okay.
Thank you, Mr. Chairman.
What time is civil judiciary meeting? No.
Okay. All right, so where we are is we have a motion now with a time change that we postpone further consideration of House Bill 50 until tomorrow's meeting, which will be at 3 p.m. Any further discussion on that motion? I'm trying to be very, very fair to Chairman Forster. Any further discussion? Hearing none, all in favor of that indicate by raising your right hand. Okay, any objection? Same indication. There is none, so that bill will go on the agenda for tomorrow at 3 p.m., and that we'll be meeting tomorrow in room 515 in the CLOB.
Thank you, Mr. Chairman. I always enjoy the lively debate from the civil and non-civil committees that I attend.
It's always a pleasure to have you. And we'll start late then. 5:15. Okay, let's come back to order. Let's come back to order, please. The chair has indicated on day one of this session when we first met that we were going to try to avoid late nights. We've done that to this point, but I'm not sure much longer we'll get to. But we've done fairly well. Let's go back to House Bill 270. If Ms. Clifton could come up, please. And I will yield the chair to Vice Chairman Mumford.
This is House Bill 270. It's juvenile proceedings regarding the appointment of guardian ad litems. It's brought by Mr. Ralston. Do you want to speak to it, or just have Mr. Clifton speak?
Yeah, very, very briefly, Mr. Chairman, you will recall, the members of the committee will recall that this bill was before the committee on Monday last week.
Wednesday.
And we had some discussion. That discussion precipitated the appointment by the chair, by you, Mr. Chairman, of a committee, a special subcommittee to work on some issues that the discussion produced. And you have before you a new sub, which is LC 292738S, which addresses the issues raised by that. This was the product of a lot of work by Chairman Knox, Representative Levitas, Representative Abrams, and Representative Lunsford. And I thank them for their good work. And if I could have Ms. Clifton just sort of walk us through the posture that we're in now with this bill.
Absolutely. Thank you, Mr. Chairman. Thank you, members of the subcommittee, specially appointed by Chairman Mumford. The gist of the changes began in paragraph D on page 2. Previously, it read, in all cases to which a CASA is assigned, a CASA shall. Now it reads, in all cases to which a CASA is assigned, except as ordered by the judge, a CASA shall. The remaining changes occur on page 3. Predominantly in paragraphs, or all in paragraphs F and paragraphs G. And I'll go through these, and if you have questions, probably a good idea to go ahead and raise those as I bring them up, if you would like. The primary change in paragraph F and the concerns that were raised were, we had the term investigations in there, and so we struck the term investigations from the previous bill and inserted the new language, judicial citizen review panels. And other significant changes of circumstances of the child's case to which the CASA has been appointed was already in the last version that you looked at, but the new language that was added was to the same extent and in the same manner as the parties to the case are notified of such matters. That just really addressed notice issues that were brought up by Judge Miller at the last meeting, and again, our attempt to address that. The next change is in F2 on line 9. A CASA shall be notified of the formulation of any case plan of the child's case to which the CASA has been appointed and may be given the opportunity to be heard by the court about such plans. So shall was changed to may. And then the last changes were in paragraph G. Instead of referring to paragraph G, because it was a good bit lengthier than what we have here, the gist of it was there were two primary concerns raised. The access to records and the laundry list of records that we were attempting to access was causing some degree of concern. And so we took that language just out of the bill altogether. The other area of concern was around the child's access to the child's family's records. So we also took that language out in hopes that would resolve some of our concern. So the new language now reads, upon presentation of an order appointing a CASA as a guardian ad litem, such CASA shall have access to all records and information relevant to the child's case to which such case has been appointed when such records and information are not otherwise protected from disclosure. That last phrase, are not otherwise protected from disclosure, is in there because of mandated reporting statute, which is already law, and if a mandated reporter is involved, we didn't want this to be an issue here, and so it's otherwise protected from disclosure as it relates to that specific statute. And we were talking to Ms. Travis earlier, and when I explained that to her, she mentioned that we could cite that code section if need be for clarification, and we're happy to do that if Chairman Knox sees that that's the appropriate response. And then the last change that we made, we kept in the exception language as it relates to the Office of the Child Advocate and DJJ, And then the last sentence, the CASA's right to access such records shall be as otherwise authorized by law. The previous language read, the CASA's right to access such records shall be as broad as that to which an attorney for the child would have. And we are good with this language.
Thank you, Mr. Chairman. And you may have just...
Go ahead, Mr. Levitt.
Thank you, Mr. Chairman.
Trying to get noticed.
You may have touched on this, but I want to make sure I understand. With regard to G, lines 12 through 15, my only concern is, and this may be what you alluded to when you said including the code section, because otherwise protected from disclosure is pretty vague and
Right.
undefined. So I would respectfully suggest that we include, Chairman, I think it's an excellent suggestion, Chairman.
By Ms. Travis.
By Ms. Travis.
You want
Better when it comes
to
to
make an
Travis.
amendment then?
I would propose an amendment that we include, and if you would, if legal counsel can give us the code section to which.
I'm sorry, I can't. I pointed out the default, but I didn't know what it was.
Let me just suggest the following. After the word disclosure, insert as provided by law. That is not, so it would read, are not other.
On page 3, line 15.
Line 15,
You need
after
this.
the word disclosure
It's not on there.
as provided by law.
The best drafting would say, see, that leaves the reader, both those that know and those that don't know, clueless as to what law you're referring to. So it should be as provided by, protected by code section blah, 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 or article such and such.
You can look that up.
Yeah, that's, we should.
Look that up.
CGA, blah, 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 I believe it is.
It's actually code section.
Code section, blah, blah. Yeah, I think we need that. I'm just concerned that if we leave it vague, and if my language is vague, let's get the code section, whatever it is, and just put it in there. Because I think we need, how do you spell that?
We have the code section.
Blah, 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 blah.
Yes, 1975.
All right, then as provided by 19-7-5, OCGA, or code section, whatever artful language legal counsel should find to comport with the general nature of what we're trying to say in our Thank you, Mr. Chairman.
That's right. Yes. I'm sorry. Go ahead. I'm sort of in my own little world.
Thank you, Mr. Chairman. At the proper time, I'd like to be recognized.
All right. Just one moment, if you'll hold that. Any other questions? If not, we have another question. Representative Frank.
Thank you, Mr. Chairman. I'd like to ask a question to Chairman Ralston, if I might. What is the purpose of the bill? We were hearing what changes were made to the original bill, but not why do we need this?
I think we needed Chairman Franklin to bring greater uniformity and stability to the CASA program. There have been some very, very isolated instances of concerns over whether CASAs were acting properly within the bounds of their authority and how they were being utilized by the court. I think this would alleviate those concerns and in addition provide some method by which now we can get at some training for these individuals. So that's the 2 or 3 primary purposes.
Thank you.
Mr. Everson, you have a question?
I have a question about a point of order. Isn't there an amendment on the table?
There is. There was a motion being made about, was it about the amendment or was it about the, all right. Thank you for bringing that to my attention. Mr. Wittis, are you you've made a motion to amend this at the point where it says from disclosure line 53 as provided by code section 19-7-5, is that the way it would read?
What?
No?
Protected from disclosure pursuant to code section 19-7-5.
Is that the way it should read?
19-7-5.
All right. There would be a period after that.
we put the language in between disclosure and period.
All right, thank you.
The period just moved.
All right.
May I,
Yes.
Jill, does that then deal with the drafting concerns you had?
No, sir.
Okay.
It doesn't fully. The other one was on line 18, as otherwise provided by law.
Would you have a suggestion?
I'm not sure what the idea is. It just, I'm not going to tell you that you don't see this all throughout the code. But since this committee is good draftsmen and lawyers that are concerned about passing good stuff, I just bring that out because it does really leave the reader to wonder. And also, this is, ACASA is going to have an order that's going to be presented perhaps to a hospital or something, and it says that they have the same right as otherwise provided by law, and that's sort of, what does that mean? And if there's something that's not allowed to be gotten to, then we should specify.
Well, maybe I can help with that. Yes, we actually worked on, we came up with that language this morning. And I think the idea is that there are some documents that are not available to the CASA because they're protected by HIPAA, federal law, mental health records, that sort of stuff that, you know, attorneys can't get them by subpoena. Some records just aren't available. So I think that's what we were trying to get at, is that, you know, they can get whatever records somebody's entitled to get, but for the fact that they're prohibited from getting them by law. And so, you know, I guess the idea was I don't want to give the CASAs a superior right to get records that, you know, that are not, that a court couldn't order open, for instance, or that an attorney can't subpoena, or you couldn't get through discovery, that sort of thing. I don't know how you draft that. I mean, that may be inartful drafting, but that's the purpose of it. Unless you list each one of the code sections where there's an exception.
Well, there's some protection in lines 15 through 17 that protect the records of the Georgia Advocate for the Protection of the Children, and then the DJJ records. So that's one exception that's specifically in there. If you want to use the HIPAA language, we did have a draft that floated out at some point that we could include the HIPAA language.
HIPAA applies whether it's in the bill or not. That's why we don't think that it's necessary to put it in there. It applies. It's federal law. It applies.
Oh, it's on.
I would ask, basically the same language in the next sentence there, where we say the CASA's right to access on line 17. The CASA's right to access such records shall be as otherwise authorized by law. I don't know what that means then in that case either. I thought what we were trying to get at there was...
You mean as ordered by court in line 21?
Yeah, right.
Mr. Chairman, I guess it's a point of inquiry to either Chairman Mumford or Chairman Knowles, or Chairman Walls today, Mr. Chairman. But I guess the point is that I think it's going to be very difficult to specify the federal and state laws that might apply in each case. And I think to some extent we're going to have a catch-all phrase that has to be tested through litigation, that has to be tested through litigation. So I would respectfully stick to my original amendment and not accept the friendly amendment and ask that we proceed just in that for the time being.
Well, my understanding is that there's no real objection to your amendment, that we're down here talking about lines 17 and 18, which there is not an amendment made. Am I missing something? All right, now let me ask you this. If, I'm directing this to council, if the CASA's right to access such records shall be as otherwise authorized by law, is there some way to turn that around while still keeping it a general statement that would make you more comfortable? No. Well, what are you saying then? That we should include the HIPAA
Well, and I agree with Ms. Clifton that the HIPAA is already out there, and we don't necessarily need to draft it in there. I don't know that this, I mean, it's not awful, it's just better practice, and better practice tells us that if we're directing somebody to beware that they're not able to get something, or able to get something, that this language, as otherwise provided by law, is just vague.
What if we just drop it? Does that change it?
Well, I guess that's sort of my point, is that if it's not there, isn't that already the case? Maybe not, says the sign.
Yes. Representative Abrams, you're just going to get us out of this.
Oh, no, I'm not. I'm just going to dig a deeper hole. No, I think that I agree with Ms. Travis that this is an elegant and imprecise language. However, I think that the CASA bill has two purposes. One is to provide uniformity in application. The other purpose is to signal to those who do not understand the role of the CASA what the CASA should be able to access. And while I do think this is inelegant and imprecise language, I do, however, have to respectfully disagree that there is a better way to answer this. Save articulating and delineating every single exception or every single authorization by law, which would make this bill about as long as the compact bill. I think we are left with this language as the best. Basically, like democracy is the best thing you can get, even if it's really bad. I don't see that there. I think there was enough conversation that to remove this language would remove one of the major purposes, which is to signal to anyone who encounters a CASA that they should have access to, and that they are through this statute, they are granted superior rights in order to protect the children that they find to be vulnerable.
Thank you, Representative Lawson.
Mr. Chairman, if I could ask a question of Chairman Rolfe real quickly. If we were on page 3, line 17, Mr. Chairman, and right after where it says Chapter 4A of Title 49, period, if we just remove the rest of that sentence, didn't we fully explain what needed to be done above it when we cited the code section and title? If we just removed that last 8 or 9 words.
Are you directing that to me?
Chairman Ralston, the author of the bill. Or to you, Mr. Chairman, either one. We got so many chairmen, I'm confused.
I would like to include Ms. Travis and Chairman Knox in that discussion, because this was language I think y'all crafted. Did you understand his suggestion, Representative Lawson?
Maybe you could repeat it.
Yes, sir. On line 17, Mr. Chairman Knox, if we went to where it says Chapter 4A of Title 49, period, and we just stopped right there, we've already defined above it what they're entitled to. It says such records shall not include the others, but above that, where everything relevant to the child's case is already included, and then we haven't made an ambiguous statement or something can be left for interpretation. I don't think, and I could be wrong, but I would just ask for someone else's opinion.
You know, on the sin list, this is really not that high. It's
So
that's pretty good.
You weren't supposed to reveal
If I may, Mr. Chairman.
Leave it as.
Yes.
Thank you. I was just waiting to be recognized, Mr. Chairman.
I'm never sure what you're talking about.
Yeah, neither am I in this room. 7 or 8 chairmen in here. With that in mind, I think Representative Salom has already requested to make a motion. Is that correct?
Well, she has, but on the other hand, there's an amendment pending which has not yet been voted on. And then we're under discussion for a possible other amendment, and we were going to try and take all the amendments at once.
Yes, I think so.
Now, I'm going to throw in my 2 cents worth. I respect the committee that was, who suffered terribly in coming up with this bill as it is. And I'm wondering if perhaps we could just delete the word otherwise in line 18 and just say the CASA's right to access such records shall be as authorized by law. Now that may not help Jill any, but that otherwise somehow just throws people off to some other place or something. I don't know. maybe I'm wrong. I'm just putting that out for discussion. And Ms. Abrams, who I have tremendous respect for her bill writing ability.
I don't see that would disturb the purpose of that line. I think we should, Mr. Lunsford, I want to call you chairman, this seems the right thing to do.
Unfortunately, that isn't appropriate title, but John's good.
I would say deleting otherwise doesn't harm the purpose of that line, and I think the purpose of that line is to signal that the CASAs have access to these records and should.
Mr. Lewis.
All due respect to my much wiser colleague, my feeling is that what you've now said is that you can do what you can do. If you strike out otherwise, what you've said is that if the law says you can do it, you can do it. And I'm not sure that really gets it. I'm not sure that it gets us, as counsel points out, with the otherwise provided either. And at the risk of stirring up the pot a little bit, if you look at line 15, then what are we saying in terms of vagueness with not otherwise protected from disclosure? By whom, by what, and by when, and by where?
But you made an amendment there.
We're clearing that up.
But I'm saying if we're limiting that, then we haven't necessarily defined for purposes of Chairman Lunsford's motion down at the end there as otherwise defined. In other words, if we're limiting the protected from disclosure as defined by there, then I don't think that the language at the end of that sentence, that language is in fact redundant, because we've limited line 17 or line 15 to that specific code section. Now we're having a broader statement at the end, but it would be my belief that otherwise included or not included doesn't make a difference.
Yeah.
All right. I'm going to recognize Ms. Abrams, and then I'm going to try and stop the hair splitting here.
I can stop the hair splitting now. I'll be quiet.
Go ahead.
No, I'm saying.
All right. Well, the first thing that I'd like to do is we have a motion for an amendment that adds at line 15 after the word disclosure the words as provided by code section 19-7-5 and then close with the period. Is that amendment accepted by the author as a friendly amendment?
Yes.
All right, so that has been accepted by the author. That does not require a vote.
It does not require a vote, but if we could restate it, it was actually pursuant to code section.
As provided, okay, as provided pursuant to.
No, as provided, just from disclosure pursuant to code section 19-7-5.
All right, as provided pursuant to.
No, as provided, just from disclosure pursuant to 19-7-5.
All right, pursuant to. Thank you very much for that correction. All right, that's a friendly amendment, and that's been accepted. Is that correct?
Yes.
All right. Now, the way I see it, this sentence that we're struggling with, there's three ways to do it. We can delete the sentence, we can delete the word otherwise, or we can leave it like it is. Those are the three options. All right. Is there a motion from any member of this committee for one of those three options, or some other option you may wish to dream up? Representative Abrams.
I move to pass.
Move do pass. There's been a motion to pass. There's been a second. That's what you've been trying to do all afternoon.
I was mine with it when I walked in.
All right, there's a motion and a second. There's no further discussion. All those in favor of the motion to pass, please raise your right hand. All right, passes unanimously.
After all that.
By substitute. Well, or as amended.
Thank you, Mr. Chairman. Thank you, members of the committee.
All right, I'm going to continue if I'm awake. Oh. If I could have your attention. Hopefully, an easy bill, but we have one more bill, and that is House Bill 316, and the chair is the lead author, and I will turn over the podium to Vice Chairman Mumford.
Yeah.
You sure you want to do that?
This is
I am leery.
This is HB 316, Public Service Commission towing vehicles. Chairman Ralston's brought this bill. Would you please explain to the committee?
I'm going to be brief. I know this bill's been through subcommittee. I have two technical experts here to help, but it came to my attention through the Public Service Commission some time back that we have here in Georgia law an intra-city exemption from certain methods of regulating activities by certain businesses here or within a city. I introduced two bills, one of which got in a much inferior committee the other day that had dealt with moving companies. This one deals with tow truck operators, and basically this would provide concurrent jurisdiction over tow truck operators between the Public Service Commission and the municipality in which they were operating. It eliminates the intra-city exemption. Part of the problem is that there's no one to check up to see if these businesses are in fact operating only within a city. The problem when that's occurring is that oftentimes they're not bonded, they're not monitored in any way, and consumers are having to pay outrageous fees for their services and being actually put at risk by their conduct. And so this bill would hopefully eliminate that problem. I think it's a very good pro-consumer piece of legislation. I'm glad GMA stuck around with us. GMA has endorsed the bill. Towing and Recovery Association of Georgia has endorsed the bill. And so I think all the folks that really care about seeing some loopholes closed up have worked together to create this bill. Mr. Chairman, with your permission, I'd like to have Bill Edge and John Tucker, two attorneys from the PSC, come up and...
He's an attorney, I'm not.
I'm sorry. Bill Edge and Attorney John Tucker from the PSC come up.
Before we hear from them, I think there was a question. Comment?
Mr. Chairman, I've met with GMA on this issue. Marcia Rubin, and they're totally in support of that unanimous out of your committee. I'd love to be recognized for a motion and let Bill go home early because he goes to Iraq in about 20 days.
Oh, my goodness.
That's a very good... all right, is there any objection to a motion at this time? Is there any need for further discussion? I'll recognize the chairman for a motion.
Make motion to pass.
Second. Seconded by... all those in favor, raise your right hand. Passes unanimously.
Thank you.
The benefits of having the last bill.
Thank you. Okay. We haven't adjourned. We have not. I guess you're really glad now that you're not having to hear 185 any further today? Okay. We have at least one bill on the calendar on our agenda tomorrow. That's House Bill 50. I anticipate putting at least one other bill on there, and I am hopeful that we will get in further guidance tomorrow on what our schedule will be after next Tuesday so that we can talk about scheduling. I don't have to remind members of this committee that we are at a fairly critical point in the session in terms of rolling up. What is today, day 23?
Yes.
23. So we don't have too many days before day 30 gets here, and so things are going to get busier. But I thank all of you for working hard today, and I'll see you at 3 o'clock tomorrow afternoon in room 515 of the CLOB. We're adjourned.